Good afternoon and welcome to the final seminar in our 10th anniversary Greater China Legal History seminar series. My name's Stephen Gallagher and I'm very pleased to introduce our speaker to you today. So before we start though, please remember we will try and leave some time at the end for some questions. I'm sure you will have some questions, so please remember you can chat your questions in to me and I can ask our speaker at the end those questions on your behalf. So we are very pleased to welcome at CUHK Law today Dr. Christopher Munn. And Chris Munn, of course, spoke for us last in the Greater China Legal History seminar series back in October 2021 when he talked about magistracies in colonial Hong Kong, and he talked to us about CUHK, and of course he'd just published a book at that point as well. So today, Chris is going to be talking to us about deportation in Hong Kong history. And as a very brief introduction to you, I'm sure many of you already know Chris anyway, I'll just say that Chris served as an administrative officer in the Hong Kong government and in various positions in the Hong Kong Monetary Authority. He's a graduate of the University of Oxford. He has a PhD in history from the University of Toronto, and his publications include Anglo-China, Chinese People and British Rule in Hong Kong, 1841 to 1880, Crime, Justice and Punishment in Colonial Hong Kong with May Holdsworth, which of course was the book which involved magistracies at the time, and upcoming Penalties of Empire, Capital Trials in Colonial Hong Kong. So that will be coming out very shortly as well. So as I said to you, Chris is going to be talking to us today about deportation in Hong Kong history. Please remember, any questions, just chat them into me and I'll ask Chris for you at the end of the seminar. So without further ado, let me hand you over to Chris.
Thank you, Jay, for that kind introduction. Thank you all for tuning in. Now, the subject today is deportation, which should, in normal circumstances, be a peripheral feature of immigration control. But in Hong Kong, for at least a century, it was an important and prominent part of the criminal justice system. Next slide, please. And this is what I'd like to focus on today. I'd like to talk about the extensive use of deportation, both as an adjunct and as an alternative to the criminal justice system. And I will explain how the deportation system was decided by the Governor in Council, not by the courts. It was a secret process. It was done in the absence of the deportee, at least until the deportee was deported, and it was refined and expanded over the decades so that by the early 20th century, it became quite an important part of the criminal justice system. Now, the courts did get involved. At certain times, they could recommend deportation for people they sentenced. They also punished people who returned prematurely, having been deported, but the courts were largely unable to provide redress in cases of alleged abuse. Next slide, please. Let's start with the case of Li Yao, a man who was initially sentenced to 3 months imprisonment in 1915 for receiving stolen property. And on top of that, he's banished for 5 years by the Governor in Council, by EXCO. And he repeatedly returns from banishment, as deportation was often called, until eventually he's caught again in Hong Kong and given 6 months for receiving stolen property. Now, those sentences for the actual crime amount to 9 months, but the sentences for returning from deportation total about 7.5 years. This is an extreme case, but it's not exceptional. There are other similar cases, repeated returns from banishment. Let's have a few definitions. These are from the Oxford English Dictionary. Deportation means simply the forcible removal of a person from a country or jurisdiction. And It's not to be confused with some other forms of removal, although, as we will see, there was overlap between these categories. The second category we might look at is rendition, which is simply the surrender of somebody to another jurisdiction, usually for trial. And then the more complex process of extradition, where usually another jurisdiction asks for an alleged fugitive offender, and there is a process for delivering that person back or not delivering that person back through a judicial process. And then finally, transportation, which is simply a punishment, removing somebody from Hong Kong or other places to another colony, a penal settlement. This was used extensively in the early years of Hong Kong, up to 1858, and there were attempts to revive it later in the century. And the deportation system throws up all kinds of other terms. I've listed some of the different ways in which it was described, both in the legislation and in other documents. It is interchangeable almost with banishment, although there are subtle differences. There were attempts to disguise it as simply repatriation, sending people back to where they belong. And then there were other phrases used by the police and in the Executive Council minutes to send away, to send off, to send on, to remove, or as the police sometimes put it, to deal with. Hong Kong had a number of special factors that were used to justify the policy of deportation. In the first place, it was largely a population of immigrants and sojourners, people who stayed here for short periods. It wasn't until the mid-1960s that the majority of the population was actually born in Hong Kong. There was large-scale migration to and through Hong Kong to other places. And these people who were not born in Hong Kong or were not naturalized as British subjects were treated as aliens under British and Hong Kong law. Another factor is the high level of crime in Hong Kong throughout the period that I'm covering. It ebbed and flowed. It was often exaggerated. Crime panics were often used to justify repressive measures. But generally speaking, there was a serious problem with crime, particularly cross-border crime. And during times of war and disorder, which, although were not quite continuous during this period, they cropped up quite often. There were troublemakers who caused problems to the colonial government and who needed, according to the government, to be ejected. The other major factor is the problems with the criminal justice system. The police, at least up to the post-war period, had very poor detection capabilities. There were problems in court with evidence, not least from the police, who often didn't know how to give evidence. And there was a general view, not just among the Western colonial elite, but among leaders of the Chinese communities, that prison was a poor and insufficient deterrent to crime, and moreover, it was expensive. It was a drain on the revenue. And finally, partly for all of these reasons, Hong Kong was regarded by policymakers as a special place requiring special laws, a factor that was acknowledged by the Colonial Office in London. Now, the scope of this presentation, we could go on quite a long time about this, but I'm trying to contain it to deal mainly with these two main categories. So-called dangerous or undesirable persons who didn't usually go through the justice system, and discharged prisoners who did. We'll also touch on the question of mendicants or beggars, and briefly we'll look at Hong Kong's role as a transit point for deportees from other colonies. What we won't look at is the deportation of the German community during World War I, the deportation of white women and their children in World War II, shortly before the Japanese invasion, the 1 million deportees who were repatriated under Japanese rule, the question of confidential banishments after World War II, deportation as a regular feature of immigration control, and the special topic of repatriation of Vietnamese migrants in the 1990s. These all, I think, deserve special presentation, so I won't really go into them. Now, there was a lot of legislation on deportation. The government could legislate freely during this period, and it did. These are all of the ordinances that dealt with deportation during the period. There may have been others as well which mentioned it. You'd be pleased to know I'm not going to go over all of them. What I'm going to do is focus on the ones highlighted in red here, which will provide us with the structure for this presentation. And this is the structure. It's divided into broadly chronological periods, some of which overlap. We begin with the Second Opium War, 1857 to 1860, which prompted special measures. There was deportation before this period. I'm not going to go into that because it was rather complicated and rather messy. The second topic we'll cover is the branding and deportation scheme that was introduced in the 1860s and was in force for roughly a decade. Then thirdly, we'll look at the expansion and establishment of deportation as a way of dealing with discharged prisoners and undesirables. Then in the early 20th century, the system was simplified, at least that's what they said, and consolidated and expanded further. Fifthly, we'll take the opportunity to look at some judicial challenges in the early 20th century, notably the case of Ho Chi Minh, but also one other key case. Then we'll look briefly at World War II, and finally, we'll look at the situation after World War II, leading to the end of deportation as a criminal justice measure. Let's begin with the war measures. During the Second Opium War, Hong Kong was subject to a number of terrorist attacks, incendiary attacks, the famous poisoning case of 1857, and various other attacks on colonists. And as special measures to address these attacks and to deal with unrest in the Chinese population generally, the government legislated these two ordinances, number 9 of 1857, number 8 of 1858, one for better securing the peace of the colony, the other for the regulation of the Chinese people. These targeted Chinese, they have to be read together, and although they were introduced as emergency measures, they were retained for 2 or 3 decades until another system was introduced. The system was basically as follows. The Governor in Council could deport any non-British subject suspected of being an enemy or otherwise dangerous. And separate from this, a magistrate could require any Chinese to find security, to get two people to vouch for his respectability and put in bonds for him to appear in court within 12 months. This is not just convicted people, this is anybody who was Chinese, who was under suspicion. If the person was unable to find security, he was then automatically, under the legislation, deemed to be a dangerous person and made liable to deportation under point 1 of those bullet points. No punishment seems to have been specified in the legislation, but from 1871, under an amendment, 1 year's imprisonment was prescribed for disobeying a deportation order. That carried on up to 1882 and in modified form beyond. But in the meantime, there was this special scheme that was introduced by Governor Sir Richard Macdonald in the mid-1860s. Macdonald was the most explicitly racist of Hong Kong's governors, which is saying something, particularly of this period. And he believed, with some justification, but with his characteristic exaggeration, that Hong Kong was faced with a moving mass of crime and vagabondage caused by its immediate proximity to millions of the worst population of China. And he also believed that English law was fine for the English, was excellent in Middlesex, or Kent, as he said on another occasion, but it was inapplicable to a settlement only a mile from the Chinese mainland. Remember at this time that the new territories did not exist as a part of Hong Kong. The border was Boundary Street, the harbour was fairly open. It was a place that people could come and go to very, very easily. And so he introduced a range of special measures to manage crime among Chinese, and all of these were targeted against Chinese. Registration and surveillance of the population, a much greater use of flogging as a punishment, flogging with the lash, and not just with the rattan cane, and a policy of clearing the jail through branding prisoners, early release long before the expiry of their sentences, and then deportation. That was his proposal. Now, when he came to Hong Kong in 1866, the jail was getting very, very crowded, so much so that his predecessor had built a new jail on Stonecutters Island. That jail was never used, and Macdonald closed it down, and he was able to reduce the population of Victoria Jail by about half. There he is visiting the jail, inspecting the jailers with the Captain Superintendent Police following him, looking a bit scared because everyone was scared of Macdonald. He was a very fierce, difficult character with no tact about him at all. And this is what he proposed. In an ordinance called For the Maintenance of Order and Cleanliness, which contained all kinds of exotic provisions, Section 15 introduced a penalty for returning from deportation. And the penalty was imprisonment for a month, only a month, branding, and to be once or twice publicly or privately flogged with the cat of nine tails, up to 36 strokes each time, and to be deported again for any length of time. And there was also a fine or imprisonment for harbouring somebody who had returned from deportation. Notice he actually uses the term sentence here. May become significant later on. He regards deportation as a punishment. Now, this ordinance is not commenced. It's enacted, but it's not commenced, because at this time, in fact, only a year before MacDonald arrived, rather ironically, there was an amendment to the letters patent to the governor requiring special permission from London for any legislation that introduced disabilities for people of African or Asiatic descent. It is rather ironic because, as I've said, this governor was a racist, and his legislation was extreme in its discrimination against Chinese. The response from London was that the provision, that particular provision, Section 15, was disallowed. That was Lord Carnarvon, but after he left office and was replaced by the Duke of Buckingham, who wasn't quite so fastidious about these things, after some persuasion, he allowed MacDonald to reenact the provision, but it had to have a proviso that the returned deportee must have committed another crime before being branded and deported. Now, MacDonald ignored all this and introduced a very different system outside of the legislation. This was a system, I guess it came under contract law, if anything, where prisoners could petition the governor for a conditional pardon and early release with branding and deportation. And they would agree in the petition that if they returned to Hong Kong, they would receive 36 lashes of the cat o' nine tails and to be deported again. There is a version of the petition in the illustration here, the bottom half, where the first 39 prisoners apparently voluntarily petitioned for this. Now, the branding was not branding in the sense of burning a mark. It was a tattoo with Indian ink on the earlobe, on the left side, on the left earlobe. Now, this ran into trouble. In 1870, Charles May, of all people, a magistrate quite famous for being quite harsh with his punishments, great supporter of flogging, he started to question the legality of the scheme. Of course, this went on when MacDonald was on leave. Nobody would have dared to raise it while he was in Hong Kong. And May pointed out that this system was operating entirely outside of the normal judicial system, and it was a private system implemented by MacDonald, and his his chief jailer, Francis Douglas. And not only that, but the system was targeting very minor short sentence offenders, not the hardened criminals that MacDonald claimed were the target. And they were often brought in by informers, by Daniel Caldwell's team of informers and secret police, who were very active in the Chinese community. Caldwell was in charge of the gambling monopoly police, which was another innovation from MacDonald, which again was challenged in 1870 when he went away and rather quickly abolished. The case is put up to the Attorney General, Julian Pauncefort, later to be a very prominent diplomat. And he advises quite simply that the scheme is illegal. It's contrary to the letters patent and royal instructions because MacDonald is issuing conditional pardons without consulting EXCO, which he's required to do. And it's also contrary to Hong Kong's own legislation, which requires anybody returning after being ordered to quit to be taken before a magistrate and dealt with by the magistrate. So this scheme is suspended in May 1870. But we do have some statistics. Even though it was a secret system, the jailer, Douglas, produces these for a commission into the police some years later. The middle column is the relevant one for people who were tattooed on the earlobe. But the other columns are also interesting because the 1857 arrangements were still being used. People were still being deported without being prisoners and without being branded. MacDonald then negotiates a legislated version of the system. And in fact, this becomes his last piece of legislation before he leaves. And this comes in the form of Ordinance Number 4 of 1872 for the branding and punishment of criminals. And it reinstates the petition scheme, but it brings in the magistrates who were to punish people returning from deportation. The punishment was that they would serve the rest of their original prison sentence. And in addition, if the convict was so brutal, inveterate, or mischievous, he could be flogged, meaning in this case, caned with the rattan, because that was the only flogging punishment that magistrates at this time could impose. The Secretary of State, another Secretary of State, Lord Kimberley, a Liberal, makes the comment, I cannot believe that the right way to treat people lower in civilization than ourselves is to descend to their level, but he nevertheless sanctions the ordinance on the grounds of Hong Kong's peculiar circumstances. MacDonald's justification for this is that the branding on the ear incurred little disgrace for the deportee when he returned to China, because people would laugh it off. You know, it's just one of these strange things that the barbarians do. And he says that is why so many of the prisoners petitioned for it, voluntarily, according to him. But there are other reports of what happened to these men. And they were said to hang around the border towns of Kowloon City and Shamshui-Po. They were unable to find work in China, and they were unable to emigrate, which was a big thing at this time, possibly fortunately for them. And they were driven back on the colony as robbers. As Chief Justice Smale, roughly at this time, said, the whole system actually enlarged the criminal community of Hong Kong rather than reducing it. And some of them, before they returned or after they returned, they tried to bleach off the tattoos, and some of them even cut off their earlobes. In view of this, from 1872, the new governor, Kennedy, who has reservations about the system, but nevertheless goes along with it, he decides that the tattoo should be on the neck rather than on the earlobe, and a bit later on it's moved a bit higher up behind the ear so that it's more visible to the police. We don't have statistics for the second half of the period. They may exist, but I haven't been able to find them. But this is a list of, I think it's about 40-something people who were subjected to the scheme in a single month in January 1877. And the list is interesting because it's the whole spectrum of crimes, everything from not quite murder, but serious robberies, down to simply being a rogue and a vagabond. And all these people, or nearly all of them, except I think for some of those in the right-hand margin, they were all tattooed and deported, sent across the border. Now, this is for 1 month. And the reason we have this is that it was sent back to London by Hennessy, Governor Hennessy, who succeeded Kennedy in 1877. That's the only document I've been able to find, but as I say, there may be others. Now, Hennessy, as I think is well known, was a liberal-minded governor who tried to put Hong Kong back onto the same footing in criminal justice as in England. He didn't completely succeed, but he did, as is well known, he reduced the use of flogging to the same level as in England, and did various other things to include Chinese in government. But he specifically targeted this branding and deportation scheme. First of all, he put an end to it, and he found many abuses. He found, for example, that some prisoners were branded only a day before the end of their sentence, and that various petty offenders against whom no real compelling evidence could be found, because they were unable to find security, they were being deported in quite large numbers. And Chief Justice Smale then chimes in. He says to Hennessy privately that he didn't want to deal with any of these cases because he didn't want to embarrass the government. Hennessy says, "Don't worry, it's not my policy, you can do what you like." And so Smale comes in and condemns the system, particularly the 1857 ordinance. It's an extreme measure, conferring most extraordinary powers, granting away the ordinary rights of the subject. And it was passed in a season of fearful panic, but still the power was excessive even then. The idea of embarrassment here that Smale refers to, I think it will crop up again and again. The fact that the government might be embarrassed to talk too much about this scheme. So after a few years of toing and froing between Hennessy and the government in London, where various drafts, various ordinances are discussed, some ordinances are even enacted, but they are rejected. Finally, we get Ordinance number 8 of 1882, the Banishment and Conditional Pardons Ordinance. But banishment is being used at the request of the Colonial Office because they say banishment is just getting rid of people, deportation is moving somebody. That was their definition at the time. And this ordinance is a consolidation. It repeals all the previous legislation. It does, however, keep the 1857 provisions, but in modified form. It no longer refers to enemies of Her Majesty, emissaries of the Chinese government, and so on. So those provisions are kept in. And there is a further provision in which the Governing Council may prohibit any non-British subject from residing in Hong Kong for up to 5 years. And the penalty for return was imprisonment for up to a year, with guilty pleas being dealt with by a magistrate, a provision that was retained almost to the end of the period we're dealing with. And there was a further provision which again repeated the 1860 conditional pardon arrangement, where the governor could pardon any convicted offender subject to his, or usually his, quitting the colony, and returnees will be sentenced to serve the residue of the sentence. Now notice here that there are no references to Chinese. There were in the original draft of the legislation, in the bill, but the Chinese member of LegCo, temporarily member of LegCo, Choi, Wu Ting-fang, who's pictured here, put in an amendment and said, why are you targeting the Chinese? Why not just make it all foreigners? And that's what was agreed. In fact, it has to be said that the original draft of this by Hennessy and his Attorney General was much harsher than what emerged as a result of debate in LegCo and discussion with London. After Hennessy leaves in 1882, his successors expand the system and elaborate on the system. I've given a few examples here, but there are various others. The mid-1880s was a period of disturbances in Hong Kong. The Sino-French War of 1884 led to protests and some rioting in Hong Kong. That led to the emergency enactment of a peace preservation ordinance, which was reenacted in permanent form in 1886. And apart from its many quite repressive provisions, one of them was the power to banish any non-natural born British subject when a peace proclamation was enforced. Peace proclamation was usually only enforced for a few days or a few weeks. So these were temporary emergency arrangements. But it's interesting how we see the gradual encroachment onto British subjects. Now, meaning in this case, basically British subjects who've been naturalized in Hong Kong, Chinese who naturalize as British subjects, not many of them at this time. Then there are various provisions in other ordinances that introduce banishment as a punishment. I give one example here, the Gambling Ordinance of 1891. Under the Prisons Ordinance of 1885, people who were convicted of returning from banishment were required to wear fetters during the whole term of imprisonment. And from 1885, there was an explicit policy where any Chinese twice convicted of a felony, that's a serious crime, were to be put up for banishment on the expiration of their sentence. That means there was to be a recommendation to the Governor and Council, EXCO, that they be banished. This had the effect of pushing down prosecutions of quite serious crimes down into the magistracy, robberies and so on. The magistrates, whose sentencing powers were quite limited at this time, maximum of 6 months for most offences, they would sentence them to short prison sentences, and then there would be banishment. And at this time, rewards of $50 were instituted for information on returnees. $50 was an enormous amount of money in those days. There was general support among the respectable classes, both Western and Chinese, for deportation. The Police Commission in 1872 praised MacDonald's branding and deportation system and recommended its reintroduction. The Jail Commission in 1886 advised that the jail should really be replaced by repatriation, as they put it, and whipping, and for the offence of returning from banishment. And in 1893, a petition from 17 very prominent Chinese, most of them justices of the peace, urged on the governor that the most efficacious way to prevent persons from committing crimes in the colony is not to enlarge the jail, but to use more frequently the power of banishment and the rattan. This was a time when the jail was in such a bad state that the Colonial Office in London was instructing governors to do something about it. The result was a near rebellion by the leaders of the Chinese community. They simply didn't want to spend money on a jail extension or a new jail. Here's an example of how this sentencing worked, even in the Supreme Court. June 1894, a man called Leung Yu is convicted of robbery with violence. a rather nasty case where he and another man who's not arrested throw pepper into the face of a woman and beat her up and take her jewelry and money. Now, for an offence of this kind, he was liable for imprisonment up to life. And in addition to up to 3 private whippings, by now whippings were not public, up to 50 lashes each time on the back with the cat o' nine tails. But instead of a long prison sentence, he gets 1 year's hard labour, 2 whippings, 25 strokes each, and a recommendation from the judge that he be deported at the end of the sentence. And this is all explained to him by the judge, the acting Chief Justice Edward Ackroyd, in that small press clipping that gives an account of the case. By the end of the century, by the early 20th century, the Captain Superintendent of Police, F.J. Badley, is urging banishment, not just of prisoners, but of any rascal who was caught in the colony. Now, the reason he's recommending this is that the governor of the time, Sir Henry Blake, is quite reluctant to deport people. According to Badley, Blake requires evidence, good evidence, that the prospective deportee has been engaged in criminal activities, and if he doesn't have that evidence, he refuses to do it. And Badley is very critical of Blake for this reason. But as soon as Blake leaves, things take off. Blake leaves, I think, in October, November 1904, or is it 1903? This is the next set of exco minutes after his departure. The officer administering the government is F.H. May, later Sir Henry Francis May, governor of Hong Kong, Sir Francis Henry May. We'll hear more from him later. But here we have over 100 prisoners put up for deportation, and about the same number of undesirables put up for deportation in a single exco meeting. And you note that it's agenda item 1 at this point. And in November 1904, the acting Chief Justice, Sir Henry Berkeley, presides over a maiden sessions, which is a criminal sessions. The criminal sessions were held monthly for a few days. And on the occasion where there were no cases for trial, as in England, the registrar or some other official would present the Chief Justice with a pair of white gloves, signifying the purity of the community and the absence of blood. Now, these happened quite often, actually, in the late 19th century and early 20th century. Not so much because crime was crime was resolved, but simply because so much of the business was pushed down to the magistrate's court. And Berkeley says, he praises the police, but he also praises the authorities for the method, brackets, deportation, that they had of dealing with criminals. This is interesting because Berkeley had previously been Chief Justice of Fiji, and he had made quite a point of refusing to allow deportation in Fiji to remote islands of what were called disaffected natives. He was removed as Chief Justice and he was sent to Hong Kong as Attorney General. And as Attorney General, when the Chief Justice was away, he acted as Chief Justice. So that's an interesting comment. There appears, at least on the surface, to be some truth in the idea that deportation was a deterrent to crime. These are some statistics from these few years. And you'll see that up to 1903 and 1904, at least the early part of 1904, the number is quite low. We don't have a distinction for those first 2 years between prisoners and undesirables, but there were very few anyway, relatively few. And you'll see on the right-hand columns that serious crime goes up in 1903 and then down in 1904. There must have been other reasons for this. It's very easy to try and find cause and effect. It was very easy for Badley to do that, but there are other reasons that I think ought to be gone into. But that's the situation in the early years of the 20th century. It's worthwhile saying something here about how these returned deportees were identified, because at about this time, the process of fingerprinting of prisoners was brought in. Fingerprinting was not really used to detect crime until at least the 1930s. It was used mainly to keep track of prisoners and for licenses issued to hawkers. And before fingerprints came in, the 1840s, the brutal regime of Colonel Kane resorted to cutting off the queues of Chinese offenders, which was a terrible thing to do. And it was stopped in the late 1840s. In the 1860s and beyond, flogging marks on the back were often used to identify former Hong Kong prisoners. And as we've already seen, from 1866 to 1877, branding marks were used. And from about this time, 1870, possibly earlier, the government began photographing prisoners. And then from 1905, the fingerprinting began and expanded into the early 20th century. Then in 1912, shortly before Sir Henry May's return as governor, a new regime is instituted. This is Ordinance Number 9 of 1912, and this is a much tighter regime. The Attorney General describes it as a simplification, which in some senses it was, but it's actually quite a lot more severe than what went before. People who were put up for deportation would be arrested and detained in a house of detention, which was actually the jail, or they could be bailed. Most of them weren't. Then the Registrar General was required to interview each detainee, or at least one of his staff was required to do the interviewing. This was known as, what later on became known as the long process. There was an investigation, albeit a rudimentary one. And the Governor in Council, EXCO, could issue a deportation order against any non-British subject. The order had to specify the grounds and the period of deportation. The deportee would be under arrest by the police until departure, and there were penalties for premature return. These were graduated according to the length of deportation, which now could be up to life. It's no longer restricted to 5 years. And again, the magistrate could sentence up to 1 year if the plea was guilty. This is the formula for the long procedure, the questions that needed to be asked. Quite simple. They were asked usually in the jail without lawyers present, and basically, who are you? You've been accused of doing this. What do you have to say? Do you have any witnesses to bring? And that was it. This was part of the schedule of the ordinance, and it becomes important in the Ho Chi Minh case, because any deviation from this was a problem. It was at least a problem for the authorities. Now, when May gets back, there he is in his vice-regal outfit. he starts elaborating the scheme. I won't go through this in too much detail, but and this is really just a skeleton of what happened. There was a reintroduction of flogging, real flogging, because May had reintroduced the cat o' nine tails, which Hennessy had abolished. The governor was empowered to specify the ship or the train on which a deportee should be deported. That became important in the Ho Chi Minh case. And he introduced a summary procedure where there was no interview. This was initially used only for convicted persons, but it was expanded over the years. In 1921, the Governor in Council could summarily deport any alien if it was conducive to the public good. That was a matter of opinion for the Governor in Council, and no grounds needed to be given for that. And from 1931, court or magistrate could recommend deportation on conviction for any offence. And then in the mid-30s, there are separate ordinances for aliens and British subjects. There were deportation arrangements for certain British subjects, but they were subject to a judicial procedure. Interestingly, a procedure that became the basis for the modern immigration deportation arrangements. And there were distinctions between British subjects who were Hong Kong belongers. I think the first use of the term, in legislation at least, people who had been here, British subjects who've been here for 7 years or more. I'm not going into British subjects too much, but we have to address it a little bit later on. This period in the early 20th century, as is well known, was a period in Hong Kong in the region of multiple challenges to authority, strikes and boycotts, many of them against other foreign powers, but some of them against the colonial authorities in Hong Kong, including the great strikes of 1922 and 1925 to 26. There was revolution in China and consequent disruption in Hong Kong. There was Indian nationalism, which became relevant in Hong Kong because of the large number of Indians in the police and jail service and in other walks of life. And Hong Kong, being a free port and a relatively free place, became a base for anti-colonial and anti-dynastic movements in other places in the region. And from this time, we get more regular statistics in the annual police reports. Here's a sample from 1920. You'll notice the deportations from other places, not just British colonies. The first line and the last line are the only ones relevant to Hong Kong here, to Hong Kong itself. All these others passed through Hong Kong. Then in 1933, it becomes more systematic. The first two columns, I think, I can't quite read that, I'm sorry. It refers to the Hong Kong cases, and then all of the others, I think, nearly all of the others refer to people sent via Hong Kong to China from other colonies. And we see quite a large number of jail discharges, 4,000 odd in 1933. This, I think, has to be qualified. The police were dealing with fingerprinting of all prisoners in this particular section, and although it comes under the Deportation Office, the jail discharges, not all of them were deported. Looking at the individual cases in the EXCO minutes, it seems that something like between a quarter or a third and about half of prisoners were deported. These are just sample soundings that I've taken. I haven't done every year, and I don't think I will do, but that's just for reference. but you'll see the numbers are quite considerable. Sorry that table is a bit faint, but it's thousands of undesirables and large numbers of prisoners, even if that discount that I've just described is applied. And here is how they were dealt with in EXCO. This is during the Clementi period. Now, Clementi was a Chinese scholar, very well connected with the Chinese community, particularly the Chinese leaders. And there was by now a Chinese executive councillor, one Chinese representative on the council. And after the very long list of prisoners and other undesirables, there are some cases where queries are raised, where the police are told to go back and check, where prospective deportees are given an opportunity to verify their Hong Kong birth, and so on. This happens increasingly, but it's still only for a minority of cases. Who were the undesirables? Well, I've put down three categories here. The top few lines, the blue cases are low-level criminals generally, or alleged criminals, and in many cases not even criminals. The middle lines are people connected directly with the judicial system, and they include some interesting cases, uncooperative witnesses, for example, and persons acquitted of crimes, particularly serious crimes. And then the purple section at the end is more political. Labour activists, newspaper editors who offend either the colonial regime or other regimes, revolutionaries and reformers, and a few minor warlord generals who take refuge in Hong Kong. And during this period, returning from banishment becomes a big issue. The majority of people are dealt with in the magistracy, and a few go to the Supreme Court, the more serious cases. Nearly all of them plead guilty because there's not much they can say about fingerprints and other identifiers. But it's quite a large number, even for the Supreme Court, at least by the 1930s, which didn't have a very large criminal caseload. Here's a list of statistics from 1935, and in this year, returning from banishment or breach of a deportation order is the largest single category of offences in the Supreme Court. There are one or two other years which are the same, but in most years in the 1930s, it's one of the top 2 or 3 offences in the Supreme Court, along with robbery and kidnapping and things like that. And the returned banishees, as they were now called, here's another new term, were often given, well, were always given the opportunity to explain themselves, and they came up with all kinds of explanations. Tomb sweeping in Hong Kong, just passing through, seeing friends, a mother to support, or obtaining money from the mother, or that they were unaware of how long they had been banished, or that they'd been sent to the wrong place, or that they were returning for medical treatment. Or in 1 or 2 cases, including 1 or 2 successful cases, they could prove that they were natural-born British subjects, meaning they were born in Hong Kong. And Inspector Vincent, who's the head of the fingerprint department in the deportation office, in a jaded remark, says in 1932, it's always the same old story, coming back to see their mother to get some money. Deportees from other places, we'll touch on this very briefly. Here's an incomplete list of where they came from. And there are 2 or 3 categories. Some of them, particularly from Singapore, are former prisoners. Others, again, mainly from Singapore, are undesirables. Singapore had a similar system. Others, though, were simply time-expired labourers who were under indentured contracts in various places, returned in very large numbers, and shipped through Hong Kong and either decanted to smaller junks or kept in a deportation shed in Yau Ma Tei, or sometimes kept in the prison, either in cells or in storerooms or even in the open air. There was a problem and various quarrels about dumping of particularly of beggars, but also of criminals from Shanghai, Saigon and Singapore to Hong Kong. There was even in the 1870s a controversy about criminals from Hong Kong, some of them with earmarks, being sent as emigrants to Australia. So there was a little bit of tension over this. During the early 20th century, there was an expansion to cover non-natural born British subjects, naturalized British subjects, and British subjects who didn't belong to Hong Kong, who were also generally white. This was extended further in 1914 to cover Hong Kong-born persons, in other words, natural-born British subjects. But if they could not prove that one or other of their parents was also British, then they were liable to deportation if they were deemed dangerous to peace and good order. And then in 1921, the Governing Council could deport any person acting in a manner prejudicial to public safety, defence, peace or security of HM's dominions. That included white people as well as Chinese. Not used very often, but the detention element of that was used by police as an alternative to the normal, more limited detention of suspects that the police were allowed at this time. Let us deal briefly with the judicial challenges. There were a few of these, usually unsuccessful, but the first successful one was Li Hongmi, the case of Li Hongmi, which is famous because it's a constitutional case dealing with the powers of a colonial legislature. It's still cited in the Privy Council in London. The origins are that in 1916, 1917, Governor May becomes aware that there are really serious abuses going on in the Supreme Court, on the civil side of the Supreme Court. Widespread champathy, promotion of litigation, forgeries of documents, even impersonations of claimants, and many bogus claims. And this is drawn to the governor's attention by two very prominent Chinese leaders, Lao Juba and Wai Yuk, who say that the people involved are solicitors' clerks and their networks of touts, and they recommend deportation. Now, May does special investigations. He's the former police chief, and he interviews judges and lawyers and members of the community, and he concludes that you can't do anything about these alligators, as they were called in the Chinese community. It was impossible to deport them because they'd only fabricate evidence of their Hong Kong birth, and in any case, some of them were British by birth and parentage. So he asked the Secretary of State for powers to deport any British subject. The target is Li Hongmei, who is about as British as you can get in terms of his nationality. He was born in Penang to parents who were also born in Penang when Penang was a British colony. And he moved to Hong Kong in the 1870s and became an interpreter in the courts. Very respected, very competent, and quite a member of the community. He had a house on Cane Road. His son was being educated in England. To supplement his pension, after his retirement in 1909, he became a solicitor's clerk for various firms, a CUHK. Very important people in Hong Kong at this time because they were often the only bridge between clients and their solicitors. So May gets authority to introduce legislation, but somewhat more restricted. In fact, this is a really weird piece of legislation. It lists a number of so-called offences or misconduct that make a British subject eligible for deportation. It specifically targets Lee Hong-mi, and this involves basically promotion of litigation, fraud in the courts, forgery of documents. It's also retrospective. May is given permission to enact that. He also takes the opportunity to enact a general deportation provision for anyone born in Hong Kong not of British parentage. Lee is arrested. He's taken to Victoria Jail, searched and fingerprinted and interviewed by the Secretary for Chinese Affairs. He asked to be allowed to see the statements against him and to confront his accusers. This is refused. He's also refused the assistance of a lawyer. He's released on bail. And then somewhat later, the governor issues a deportation order prohibiting him from being in Hong Kong for 15 years. Lee does not take this lying down. He goes to court, and the case is dealt with by the full court. Now the Chief Justice is Rhys Davis, the former Attorney General who drafted quite a lot of that deportation legislation. Lee is defended, is represented by Pollock, Sir Henry Pollock, and C.G. Alabaster, two prominent lawyers. The main arguments by them are that the allegations are criminal, but the deportee is not given the usual protections of a criminal defendant. They also claim that the deportation ordinance is ultra vires Magna Carta, which is the right not to be exiled out of the King's realms. It's also ultra vires the governor's letters patent, they claim. And there are various other claims, one of which is the humiliation of being searched by an Indian jailer in front of convicted felons. And Pollock says, is it not almost ludicrous to suggest that a British subject should be dealt with in this way? Well, Rhys Davis tends to agree. You know, he says it's extraordinary legislation, even though he's partly responsible for it. But he says that, you know, although it wipes away the liberties of the subject, the court has no power to overrule the actions of the government. And the other judge, this is the full court, the two judges, Gompertz, he's rather surprised and puzzled because he doesn't really understand where Lee could possibly be deported to, since he's from Penang and doesn't really have a lot of experience in China. But he also agrees there's nothing that can be done. The discretion of the governor and council is absolute. It goes to the Privy Council, and because it goes to the Privy Council, there are various files and lots of commentary by a startled Colonial Office. One of the legal advisors, Henry Bush, says that he's shocked comparing the ordinance with the Habeas Corpus Act and Magna Carta, and that if we'd known that this is what May was planning to do, then we would certainly not have allowed him to make that amendment. So they're rather worried. Goes to the Privy Council, and the Privy Council is not at all surprised by the ordinance. The power of the legislature is fully confirmed by the Colonial Laws Validity Act, the British Act, 1865, and they find it hardly surprising that Hong Kong should want to deport people. But there is an informality, a flaw in the order against Lee Hong-mi. Because this involves liberty of the subject, everything has to be done properly and according to procedure. And the problem was, very briefly, that there was a general charge, charge one, that you're generally promoting litigation, preparing false evidence, and so on. And then number two specific charges. Privy Council decided that these two sets of charges were linked, and they should have been only specific. And they said that the idea of a general charge must have influenced the Executive Council when it considered the more legitimate specific charges in item 2, and therefore the deportation order was bad. Li Hongmi won the case, died in Hong Kong a few years later, 1925. The question of Ho Chi Minh, I'm going to deal with this briefly because it's a complex case. It's a well-known case, and there is a recent book on the topic, which I'll mention at the end of the presentation. As is well known, he's wanted by the French authorities, he's arrested in Hong Kong. French ambassador in London asks for appropriate action. He doesn't mention extradition because that would have stymied the whole business. And the government in London instructs Peel to deport Ho to Saigon on a prescribed ship. Peel arranges this. His people mess up the procedures. They start off using the long procedure, which they make a mess of. Then they simply use the summary procedure. And Ho's lawyers take the case to court on the basis of invalidity of the deportation orders. If the first one was invalid, the second one must also be invalid, even if it was properly drawn up. And they claim that this was extradition under cloak of deportation, that the government is using deportation as a quick way of getting somebody extradited for a political crime, which would not be allowed under normal extradition rules. The full court considers this in September 1931. Ho Chi Minh, who in all of this proceeding is known as Sung Man Chor. He's posing as a Chinese journalist. And that is the term that is used in all of the judgments and all of the proceedings, even though they know he's really Ho Chi Minh. Goes to the Privy Council. For some reason, the Colonial Office engaged Sir Stafford Cripps, a communist sympathizer, who gives them private advice. He says basically, this is terrible. You're out for a witch hunt, a manhunt. A lot of unpleasant things will come out in court if this proceeds, and it will be very embarrassing to the Hong Kong government, especially since the only evidence is that Ho is Chinese. So the case is settled out of court on the first day. Eventually, Ho is deported to a place of his own choice, which is ultimately Moscow, after about 18 months of detention in Hong Kong. This was what the governor in Hong Kong had recommended from the very beginning, Sir William Peel, a rather gentle character. But in 1933, he asks, in the light of this case, can we please be allowed to deport persons to their own country, even if they face danger there? This is not pursued, but this was at a time when various parties were asking for extradition to be simplified in Hong Kong and to be made a purely executive act rather than a judicial act. That didn't happen, but there were movements in that direction. There were other famous political deportees, Sun Yat-sen, Kang Youwei, Tan Malaka, the Indonesian Dutch East Indies revolutionary. Numerous communists were deported during the purges in Hong Kong and in Guangzhou in the late 1920s. Some of them quite possibly went to their deaths. And over this early 20th century period, various other communist labor agitators and others were deported. World War II, massive immigration in the late 1930s, fleeing the Japanese invasion, and special measures are introduced. Magistrates are empowered to order expulsions of destitute persons. There is the deportation of European women and children. There is an attempt in 1941 to introduce immigration restrictions on Chinese for the first time. It fails. And during the war, there is this awful repatriation of over 1 million people by the Japanese. After World War II, the problems and the difficulties in Hong Kong continue. There is civil war and revolution in China, leading to a mass influx of people, population which was not much more than 500,000 at the end of the war, rises rapidly to 2.5 million by 1955. There is widespread poverty and high crime rates, a lot of gangsterism, a certain amount of terrorism, and there is a revival of deportation. The Deportation of Aliens Ordinance is amended several times so that in 1948 a magistrate or a court may order deportation, not recommend it, order it, for any alien resident who is in Hong Kong for less than a year and is convicted of any offence. This is tightened up further in 1949 when it becomes automatic. A competent authority, meaning an official appointed by the governor, shall order deportation of any alien convicted of a scheduled offence. And this is a tariff ranging from life, if it's more than 6 months imprisonment, to 10 years if it's more than 18 months. There is a schedule of offences. Not all offences are covered. The schedule is expanded and amended at various stages. And magistrates, who by now have much greater powers since the war, their sentencing powers are increased generally, and they may now sentence return deportees to up to 3 years. This is the schedule. It doesn't tell us a lot because it just refers to provisions in ordinances, but among these are the most common offences: theft, dangerous drugs offences, drugs now being illegal, completely illegal in Hong Kong. And the numbers are given as far as we can ascertain them in this table, rising from over 1,000 in 1947-48 to 10,000 in 1954-55. But people return in large numbers, so that by the mid-1950s, the equivalent of all of the deportees have returned. And there are, in addition, by the way, the document on the left gives a list of crimes for 1 month for which people have been deported. That's a little bit more easy to follow than the legislation that I've just shown you. I won't go into that because of time, but the practical problems are that by the early 1950s, the Chinese authorities are just not willing to take deportees. They push them back across the border, which by now is a closed border, and the police try deporting people by sea on contracted junks, until in August 1954, a so-called deportation junk is intercepted off Zhongshan and the crew is held captive, and deportation on a large scale is no longer possible. And there are also humanitarian concerns. The people returning couldn't all be prosecuted. The courts were already overloaded. These people were subject to blackmail and intimidation, and they were literally criminalized. The heavy burden on the police, who were already dealing with crimes of poverty. And so the offences subject to automatic deportation are radically reduced. And in fact, the deportees are not deported. They're kept in the Chatham Road camp, a multi-purpose detention centre. And eventually in 1955, they are released. Most of them just released, a few hundred released under police supervision, most of whom are arrested quite soon after for other crimes. And then in 1956, just a year after all of this, we get the double tent riots, the first really serious, really lethal post-war riots triggered by KMT exiles and gangsters, a well-known event leading to many arrests. And this is blamed partly by the governor, Sir Alexander Grantham, partly on the terrible conditions and the exploitation of people's grievances, but also on the end of deportation. The result was that we were saddled with thousands of the worst criminal elements who could no longer be deported to China or even Taiwan, as a few people were. So soon after this, emergency regulations are introduced which enable detention if deportation is impossible. Initially, it's used on quite a large scale, but the numbers dwindle, and the detainees are held in various places, including the Victoria Road Detention Centre from the early 60s. I'm not going to go into this because this is a much larger and more complex subject. The expert is Carol Jones, who's written quite extensively on this. But the deportation issue lingers. Grantham's successor, one of his successors, Trench, regrets during the big crime wave in the early 70s that he can no longer deport, partly because of the practical problems, but also because the people who are mostly committing crimes are now born in Hong Kong. They're young people who are born in Hong Kong. But even those young people fear deportation, and there are various comments on this. Hilton Chung Lin, an urban council, a prominent figure in Hong Kong, asks for some kind of local citizenship to remove the shadow of deportation, even though it's not really going on a large scale. Elsie Elliott complains that corrupt policemen are threatening deportation and detention against complainants and witnesses. And Chief Justice Hogan, after the 1966 Staff Row riots, talks about this sense of not belonging. He is commissioned to do a report, and he attributes this partly to the unreasonable fear of deportation among young people. Now, this is all cured to a great extent by the Immigration Ordinance in 1971, the first modern immigration ordinance in Hong Kong. It creates the category of Hong Kong belongers, who are basically Hong Kong born, who are not deportable, and it introduces this category of Chinese residents who, if they who've lived in Hong Kong for more than 7 years, they're deportable only on the recommendation of a court or tribunal. So that sort of fills the gap to some extent. And then in 1987, in anticipation of the provisions in the Basic Law, permanent residents, including people who've been here for more than 7 years and who've been given permanent residence, are not deportable. So aliens such as myself can now live comfortably without the fear of being deported from Hong Kong. Now, a few reflections and observations. Lord Carnarvon in 1877 said that these special powers of deportation should be used with caution only in cases of security where the colony is threatened. Well, that didn't happen. Piggott, in an earlier case, again repeats what Smale and Rhys Davis and Kemp have said in other judgments, that soon as the legislature sanctions the exercise of arbitrary power, there is an end of the matter. The point to make here is how frequently legislation was enacted in Hong Kong. And beyond regular legislation, there were emergency powers which didn't require the intervention of the Legislative Council. And Sir Reginald Stubbs describes in one EXCO meeting, says that deportation is not a punishment but a preventive and curative measure. Well, I think it's pretty clear that it was a punishment, or at least an auxiliary punishment on top of prison or sometimes in place of it. We might offer some mitigating comments. Most of these I make myself. Other colonies had similar arrangements. Practically all Crown colonies by the 1920s had deportation arrangements. Hong Kong had special circumstances that required special measures. The system was regulated by law, most of it. It was supervised by London and by the courts, and it was exercised with care and a certain amount of provision. Well, in answer to that, in terms of numbers, Hong Kong may have been an extreme case. Singapore came close, I think, worth investigating further. The special case argument was used to justify any number of oppressive policies. As I've said, the law was easily and frequently changed. Supervision from London was weak and very patchy. The courts were impeded by the tightness of the legislation and by the weak constitutional protections that prevailed until the Bill of Rights and the Basic Law. Whether it was exercised with care and precision, I think is a matter of opinion. So finally, here is the summary. Deportation was a key part of the criminal justice system as a supplement or an alternative to imprisonment. It was also an alternative for alleged offenders who could not be tried by the ordinary courts, and it was a political tool. It was discriminatory, and it was largely unencumbered by the usual common law protections. And the spectre of deportation, without wanting to exaggerate the problem, because there were many, many factors involved in this, but it was an impediment to the growth of a sense of citizenship and civil society in Hong Kong, particularly in the 60s, at a time when deportation was no longer being used on a large scale. Finally, some recommendations for reading, which I'll leave on the screen for consultation later on. I think I've gone on for very long, so apologies.
Ideal, I think. Well, thank you very much.
Thank you very much, Steve.
So, thank you very much, Chris. That was excellent. A very suitable seminar for the last in our 10th anniversary year as well. Really a tour de force of the whole topic. So, thank you very much for covering that for us. We did have a number of questions. The good news is you actually covered a number of the earlier questions as you were going through. So it was nice that you sort of dealt with those. One thing did come up. It was mentioned earlier on, and then you sort of touched on it later on. I know we've only got a couple of minutes, but if I can just say this. Was there any indication early on of where people were going to be banished or deported to? Was it always back to China, or could there be deported to other places? You said later on, in 1915 that the government could specify the ship or the train.
Yeah, the vast majority of cases were to China, and people were either shoved across the border through a gate, or they were sent on a ship or a junk. Before the prescriptions came in the early 20th century of which ships, they would just be rounded up by the police and shackled and sent on a particular ferry. But there were deportations to other colonies and to other jurisdictions, including Japan, including various places in the region. We've seen the Ho Chi Minh case, and of course the fares would be paid for by the government. But I think as soon as they got on board, I don't think they were subject to any particular restraints. But yes, there were other places. And even the UK, in a very small number of cases, usually sent down from the treaty ports of British subjects who were not wanted in Hong Kong for one reason or another.
So they could be sent back, or they could be sent to Australia.
Yes, indeed. The Chinese branded deportees until the Australian governments kicked up.
There was an edit. I'll just touch on one other thing that was raised. You mentioned that this was used throughout the British colonies anyway, and particularly Singapore. But there's also the idea of using that term banishment earlier on. There was a question about whether that was linked into Chinese punishments.
Quite possibly, although I doubt it, because the people who designed all these things, with the possible exception of Alabaster, were not really very au fait with what was going on in China. In fact, they were criticised for not knowing what was happening in the larger picture. The distinction that was made in 1880-ish was that deportation required an actual transfer, whereas banishment was just saying to people, get lost. We don't want you, and if you're found within the next few days, you'll be punished. But as you've seen from some of the other slides, the terms were interchangeable. And even in the dictionary definition, I think banishment and deportation are interchangeable. It's curious that term banishment, which is really Shakespearean in its connotations, curious that should have continued to be used.
Yes, I think one point you said where it was used by prominent Chinese citizens as well.
Yes.
The banishment and the rattan.
Yes.
And then the links to cost cutting
yes.
seem to go on throughout.
I think there is this overriding concern that that Chinese in their own country were subject to brutal punishments, including banishment or internal exile, plenty of flogging with various sizes of canes, and that Hong Kong had to somehow replicate this because imprisonment was almost an incentive. People were allegedly fed better in prison than ordinary labourers outside. At least that was the claim. And so there was this attempt to match what was going on in China, but they could only go so far. Particularly during the Qing dynasty, the punishments across the border for those who were punished, and remember the reach of the police in China was not necessarily as great as it was in Hong Kong. The punishments were very severe.
Well, thank you very much again, Chris, and also thanks
you.
for mentioning Carol Jones's work again, because I think again we need to emphasise
Yes.
the work that Carol did.
Absolutely, she has a couple of chapters on that in her very important book on criminal justice. And I think in a number of other articles, she's gone into that in huge detail, and some of it's quite shocking, but well worth a read.
Definitely. So thank you very much, Chris. I think we'll call it an end to the seminar there. So thank you very much for joining us for this last in our 10th anniversary seminar series. Thanks very much to Dr. Christopher Munn for an excellent seminar to end the series with. And all I can say now is we look forward to seeing you in September when we will start our new series of seminars. So thank you for joining us today. Bye-bye.